Good morning friends, Sat Sri Akal, Adab. Today I would continue from my 79th video where I had said what options are left with a OGB or a grantee or a leasehold bungalow owner if the bungalow is in possession with the army or is in possession with tenants for the last some 50-70 years, or the bungalow is in a dilapidated situation. There are disputes between inheritors of the HOR. Mutation has not taken place for the last 70 years. So today my continuation would be on this topic only. Let's say if the bungalow is in possession with the army. In legal or in simple language it is on hire. Now we need to understand what does this word hire and what are the eventualities which will, as an HOR, we will be facing. Because most of the questions which I receive from my fellow friends is that, Mr. Das, what should we do with bungalows or with our old grants or leasehold bungalows which are on hire with the army? How do we get rid of this liability? Yes, that's a multi-million-dollar question. Because why? Let's say if your bungalow was hired in 1920, 40 or 60s, your rent being paid is a meager amount of 250 rupees or maybe a maximum amount of 2500 rupees per month. No bungalow owner would like to stake the liabilities on a meager amount of 2500. So will this bungalow get vacated? So before we move forward, we need to know whether our bungalow was leased under which agreement. Like there were various agreements which the British Army or the British laws created way back from 1899 to 1902 and then finally 1925, so which I'll speak. But I must say instantly, if a bungalow, a old grant is on hire, the law is very clear with the army that it should be resumed and not dehired or not de-requisitioned. So our liabilities are enormous. So the options with the HOR is very bleak. It's kind of a litmus test for him. Because the bungalow is there but on hire, so what is it? How does he move forward? So now let's presume the first instance that the HOR is the original HOR as per the GLR. There may be cases where the HORs are under inheritance and not the original HORs. Has the mutation taken place? There may be people who have sold the bungalows. So now there is an illegal occupant but who is supposed to be an HOR. So will the army or the department recognize him? So we need to see on what grounds are we going to seek our vacation. Is the bungalow dilapidated? Has the army or the emirs abandoned the bungalow? Why is it not being put to use? So these questions will come. And what were the 4 laws under which these hiring were taken up? They were basically under the House Accommodation Act of 1902 in 1899 bill or the 1899 Cantonment Code 1912. Similarly, 1925 and 37th Cantonment Land Administration Rules. So under these 3 columns, our bungalow must have been taken on hire. But recently there were bungalows after 1940s and 50s being hired on by the emirs, where a lease was made on a mutual agreement. Now will that be a lease under mutual agreement taken? No. There is an act called Rape Act, retrospectively passed in 1952. So we will discuss that also. So what are the options now to the bungalow owner? Please, my humble request to all who are like this and their statuses, do not file suits without getting in touch with me. I'm not being very blunt or straight on this part of getting in touch. You may have, you must have, and you would like to, whether you are in touch with me. But please make sure that your pleadings to evictions are right. Our advocates would file you on that you are the owner of this old grant bungalow. Please do not write yourself old grants. Say I am an old grant, but I do not fall under any of the GGOs passed for my presidency, or even it has not been notified for my cantonment. So these are the questions which come up. And then maybe the people who are listening to this video would say, Mr. Das, how do we move? The first and foremost is, you are seeing my mobile number, you are seeing my mail IDs, get in touch with me. Okay, so you need to move forward, and then we will start how the process should initiate. So our first initiative would be land records. Where do we dig them out? How do we do it? You can see it in my YouTubes. Second is, we can go in for an executive war or a correspondence why dehiring or derequisition has not been taken place for so many years after being abandoned or put to a dilapidated situation. So we need to get into this. So the emphasis of my research or my doing is exactly on land records. There are people who don't even know from 1970 or 60s or 50s who was the original predecessors of theirs. So please friends, 1938, 1912, 1925 and 1899 are these cut dates. Please search your land records. Get into the DEO's office, CO's office, try and dig them out. Your local tahsil in your cantonment where the registries are kept. So everything has to be done. We need to have the original lessee or the lease agreement between the HOR and the government. Now, I just mentioned above, it has to be done in either House Accommodation Act, Cantonment Code or CLA rules. Now, whether after 1950, it has to be done under a mutual agreement with the garrison engineer. So, how do we begin? Once these documents are there with us, the terms and conditions would be clear. Does that any of the lease agreement says it is a lease under repairing lease, or is it is a lease for 5 years to be renewed? So somewhere we can plead their illegal occupant sitting because after 5 years the lease was not renewed. So many things would come up. I came across a case where the lease is in perpetuity. Now imagine a lease in perpetuity of an old grand bungalow. Will it be acceptable to the court? You yourself are not willing to give us, but a lease under terms and conditions. So either one way the government says lease is in perpetuity given by the government to an OGB, or whether a lease given by an OGB to the government. So these are the kind of questions which will come up. But I must talk to you of the Lok Sabha's question which was discussed in 1970, number 3553, where it was clearly said in clause B, case of sites held on old grant or cantonment code leases, buildings which are on hire with the HOR or the grantees. It very clearly says that what I was just saying, when this policy of 1970 resumption is very clearly saying that as and when such sites are required for specific defense purposes, case for resumptions will be taken up by the authorities. This will be generally taken up zone-wise, section-wise and a cluster-wise. But in the case of a bungalow being on hire, the army can very easily say, because it is on hire, we do not dehire it. So the situation is very tough for either OGB or a lease bungalow because both are grants. One and only process what we can do is, if we can get in touch with the VVIP section of the MOD, try and get a releasing order from there that since the bungalow is not required, is not being put to use. So this is all on a 101 personal basis. Or we can go and file a suit against it, apart from that executive war or the correspondence which I told you. Because nobody in the executive war would take a decision. We will only be creating evidence on that. So the chances even in the court, if we move, are very remote because mostly the cases have been lost. So I presume on a 50-50 basis. Why am I saying 50? 50 maybe we do not get vacated. 50 even if we get resumption, you make a handsome money on it. That's my guarantee. So once these land records, which I've been insisting all along in my videos, are there in your hand, then this sword which is hanging on us of resumption, I can even take it away. How? We need to know our legal course of action. So if this cannot be dehired, it can only not be dehired if there is no surplus land in your cantonment. So these are the kind of things which I will be seeking once I plead that I need possession of the property. So fellow friends, I am there to be your guide. I am there to advise your local advocates, provided you need me. So, but your pleadings, your evidence has to be very precise. We cannot go haywire because the government will immediately come as an OGB, old grant, and they would say we are under the policy resuming the bungalow. How all this would be done? Let's sit down with DOs and COs. Let's sit down with the garrison engineer bracketed of the MES. So let us dig in our house tax property registers. Who's been paying taxes for this property since it's been on hire? Even let's say when it was abundant, where did the tax superintendent raise the demand of tax structure? If it went dilapidated, is he yet raising the demand? Because if a bungalow is not generating any revenue, the tax structure says something else. So we need to proceed. We need the most important document which may be in the hands of the Cantonment Board. That is the original sanction plan of the building. It can even be with the MES authorities or the garrison engineer. So we can dig for that. Why am I asking for this? Because it's very necessary. We need to know the original plan of the building. Then only we can claim or we can get ourselves assessed by any market valuer or by an architect that if we had to build up this property of this area, the market value could have been this much. Second, please get into your local DCs or collector offices and get the collector rate of your area so that the land, maybe 2 acres, 9 acres, we could claim the value of that land also. The Municipal Act would speak on it. Once these documents are ready, one by one, then the bungalow owner needs to move forward and talk of all these what I am talking. If the lease is under House Accommodation Act, it speaks of something else. Section 10 of it and 14 says how the bungalow has to be de-requisitioned. Now we need to get that House Accommodation Act notification for your cant. We even need to get that bylaw made for your cantonment of that House Accommodation Act. Because that bylaw will tell us on which road intersection is the House Accommodation Act being applied. Now does your lease or your OGB falls within that boundary pillars? Then only we can move. So a plan has to be made. This plan must be lying in the Cantonment Board office either. I recently got this plan of my Ambala cantonment. So all this has to be done. Then only we can move forward and make sense. Now garrison engineer of your local MES, just check up it is GE South or GE North. They must be holding some property records of yours. You can get in touch with them, try and extract your papers. So once all these departments are searched, now we know which document is there, which is not there. And the last and foremost is every cantonment or DO has to make a land utilization plan. Recently in the 2006 Act it came, or even the land surplus requirements or the calculation of the lands is done as per an order of the Cantonment Act. Please read the Act itself. So once we have that my cantonment, which the bungalow is from, is holding surplus land, the requirement further is not needed for the army, then the dehiring may take place or it may not even take place. So these all issues have to be shown to the courts. Pleadings have to be done. And then only we can even talk to the Director General, the MOD, when there is surplus land, why can't you dehire my bungalow? Why create a liability going to the courts? So even the executive as a third pillar of the constitution needs to understand this. So all this will happen one by one. So this is not very easy, but we need to work very hard. And we must start off right now because I know there are many bungalows, more than about 300 to 400 bungalows in various cantonments which are on hire. Now, if last and foremost I will speak if there is an illegal occupier or a buyer in this bungalow. For him it is very difficult. He needs to make sure that all this ex-HOR has to sign these court orders for him. or he needs to get those sale orders made in the format which I had explained in one of my earlier videos. Because then only he can file on his behalf on a special power of attorney, these court cases of it. Because I remember there is a case where the illegal occupier has not been compensated even after being an honorable judge retired of the Supreme Court. He is yet moving to different various courts to get his compensation. So just imagine the travesty. The executives at times become very cynical to the policies up there. So friends, mutation becomes very important, and you need to trust me. You need to understand these laws, the system. That is why I say get your Janam Patris made, so that we can know about your records of your land, your happenings. And once that profile is ready, it becomes very easier for me to move on the second step of filing an eviction suit for your dehiring. And now I'll speak of the last. There is an act called Rape Act, 1957, retrospectively with 13 years. So any bungalow taken from 1937 onwards or 40 has to be on either Rape Act, which has now been converted by the J.P. Mittal book, dehiring and hiring section. No, it was basically Rape Act. So once in that Rape Act, section 13 speaks, it has to be de-requisitioned. So we'll talk on all these grounds. I hope you understand. I'm once again saying that we guys are old grants, were never converted into new grants by the Britishers after 1793 or 1812, culminating to 1859 regulation. So that is why till date we are called old grants, because we were revenue-free grants either in some cases. So bungalow owners, please get in touch. Thank you. Good day.